Hello, everyone. Welcome. We are just waiting for a few people to join us. I can see that attendees are joining. We will wait for people to join and we'll start. Good afternoon and a very warm welcome to everyone who is joining us today. My name is Ekaterina Aristova. I'm a postdoctoral fellow at the Bonavera Institute of Human Rights and a co-convener of Oxford Business and Human Rights Network. It is a great pleasure and indeed a great honor for us to host today a launch of the new edition of the seminal book, Multinational Enterprises and the Law, written by Professor Peter Muchlinski, with a contribution of the new chapter from Dr. Ebbe Rogge. Professor Muchlinski is the Emeritus Professor of International Commercial Law at the SOAS, and Dr. Ebbe Rogge is an Assistant Professor at Leiden Law School. Congratulations again to the authors on this important publication. This is a collaborative event convened jointly by the Institute, the Network, and the SOAS School of Law. Scott Newton, head of the SOAS School of Law, will join us soon, and Professor Kate O'Riordan, director of the Bonavera Institute, will also welcome the audience in a few minutes. Thank you both for joining us today. Among many other issues, the book that we are celebrating today examines the social dimension of the regulation of multinational enterprises, covering labor rights, human rights, and environmental issues. This is the focus of our discussion today. Professor Muchlinski has invited several friends and colleagues to share their thoughts about the past, present, and future of the business and human rights field. We have a large and distinguished panel of eminent professors and practitioners who are uniquely well placed to discuss this topic. I will avoid long biographical summaries. Please forgive me for this. You can find those at the events page, and I will introduce the discussants in the order of their presentations. We are lucky to have with us today Professor John Ruggie, founding father of the UN Guiding Principles on Business and Human Rights, and Professor in Human Rights and International Affairs at Harvard's Kennedy School of Government, Professor Barnali Choudhury, Academic Director for UCL's Global Governance Institute, Professor Surya Deva, Vice Chair of the UN Working Group on Business and Human Rights and an Associate Professor at the School of Law, City University of Hong Kong, Rae Lindsay, Partner at Clifford Chance and co-head of the firm's Public International Law and Business and Human Rights Practices, John Morrison, who is joining a little bit later, Chief Executive Officer of the Institute for Human Rights and Business, and Dr. James Zhan, Director of Investment and Enterprise at the United Nations Conference on Trade and Development. Thank you very much to the speakers for their time and for joining us today. We are also grateful to the Oxford University Press for providing a discount code for ordering the book, and the audience will receive this information in due course. Last but not least, thank you to my colleagues, Gayatri and Lisa, who are running this event behind the screen. So without any further ado, I'm giving the floor to Kate O'Riordan, who has to leave us in a few minutes, but Kate, the floor is yours.
Many thanks, Katya, and a warm welcome to all of you to this really interesting and important book launch, not least, of course, to the authors, but also to the panelists who are here today, as well as to all of you who've come to hear the conversation. The Bonavera Institute of Human Rights is delighted to host the Oxford Business and Human Rights Network, of which Katya is one of the leading members, and it has produced an extraordinary array of conversations on important topics relating to business and human rights over the last couple of years. So we're very delighted to be partnering with them today again. And of course, we're also delighted today to be partnering with the School of Oriental and African Studies, SOAS Law School, from where Professor Muchlinski comes, and several of the other members of the panel. So we're delighted to be partnering with SOAS. This is, I think, the first time we've partnered with SOAS on an occasion of this sort. I'm really sorry that I can't be here this afternoon, but I hope that it's a really interesting discussion. And thanks once again to all of you for attending.
Thank you very much, Kate. Scott Newton, we give floor to you. Would you like to welcome the audience, please?
Yes, welcome everyone. As one of the co-sponsors of the event, I'm particularly delighted to be here. It's also wonderful for us to be able to host you in conjunction with Bonavera Events and Oxford. And it's a particular and great personal pleasure for me to open this event. I could speak at great length about Peter, who is one of my most cherished colleagues at SOAS since he arrived back in 2005. And we bonded rapidly, not only owing to our intellectual elective affinities, but our shared developmental and geographic perspectives looking to and from the Vistula East. Even though I was the Soviet law specialist and therefore an object of some presumptive suspicion, we've always had the widest ranging discussions possible, and even occasionally about MNCs. Peter has taught on my human rights course, and I very early on devoured the second edition of the book, which was published just shortly after Peter came to SOAS, on which at that point I think I could have been catechized. I'm proud to have read it, and I'm proud to have taught it. It is a magisterial treatise. And one of the things I rapidly understood after my first read was that, as the first of many, was that as a legal treatise, it was striking for its encyclopedic erudition. The political, social, economic, and historical scholarship on display was every bit as compelling as the legal. Now, the book has had a vast, expanding, and illustrious readership for more than 2.5 decades of its existence. That's a generation, and the book has a generational authority and heft to it. We at SOAS Law fancy we have a privileged claim on it, even though Peter brought it to us in tow. But if it didn't gestate with us, we have certainly presided at and sought to foster its middle and late development. So we're delighted to witness this third launch, this time with the contribution of Dr. Ebbe Rogge. It's a real jewel in our departmental bibliographic crown. And Peter is a gem of a colleague, even though he managed to step back and assume emeritus status, maintaining his productivity but preserving his sanity, just as I took up what immediately became a wartime headship. But he's been a staunch supporter throughout, and I'm grateful as well as envious. So congratulations, Peter, and welcome all.
Thank you very much, Scott. Many of us share your views about Peter's scholarship and its importance and significance in the field. Well, Peter, without any further ado, I give floor to you, and we're looking forward to hearing how your thinking about the field and regulation has changed over the last years. Thank you.
Well, thank you very much, and thank you for all that effusive praise, Scott. It's more than welcome these days. You know, as you get older, you hope that you've done something useful in your professional life, and I guess the book is about the one big thing I have done that's quite useful. But that aside, what I'd like to do today is to actually talk about how the social dimension has evolved in this book. Because when I started out teaching a course on multinationals in the 1980s, we virtually spoke nothing about social responsibility. I mean, I was lucky enough to be mentored by Professor Bill Wedderburn at the LSE, and Bill gave me that connection between corporate governance and labour issues, and at least there was a labour rights chapter. But it's quite significant, as I remember at LSE in the 80s, when the labour rights topic came up, about a third of the class disappeared, and then they came back again for technology transfer. So nobody really took it that seriously. But now the world has changed quite dramatically, and the book had to change with it. And the second edition had for the first time a social dimension, focusing essentially on kind of like the social compact issues, labour rights, human rights, and environment. But it was a long way from the second edition to the third edition, for reasons that I'll explain now in my short presentation. And the book has had to be updated really against two, I think, background flows. The first was the apparent challenge from protectionist forces to economic globalization, which was amplified during the Trump presidency, I think. And I'm not sure that we've actually stopped all of that. It's still very fuzzy to me whether the second global economy and the second globalization is over or not. And I'll have a few words to say about that in the light of the pandemic at the end of my presentation. And the second was the expansion of corporate social responsibility issues across the board. Because what distinguishes the third edition from the second is that while in the second edition, I could compartmentalize corporate responsibility, human rights, environment, and so on in a self-contained part, I couldn't do that in the third edition. And as Ebbe will show in his presentation, even the chapter on the regulation of multinational banks, for which I'm hugely thankful to Ebbe for doing, because I couldn't have done it on my own. There's a very strong corporate responsibility and corporate governance dimension, as he will explain. But also in the chapters on international investment law, sustainable development and the sustainable development goals have come into this. And no longer can we talk in terms of pure investor guarantees or protections. And I wonder if in a possible fourth edition, we won't be actually replacing the debates about the technical meanings of international investment agreement provisions with a new type of agreement, which is focused on investment protection in the context of sustainable development. In the tax chapter, for the first time, I've actually discussed the problem of tax avoidance as a moral and governance problem, not just as a technical accounting problem. And so it goes on. The sections on digital platforms, data protection has come in. So economic regulation has very much been changed. I suppose also even in the company law field, which I'm sure Barnali will be talking about a bit more, we've had cases like the Vedanta and Okpabi case, where we see the English Supreme Court actually understanding the need for a greater flexibility and accessibility to justice of victims of possible human rights violations, although these cases characterize the problems as tort problems. And, you know, we could have a whole seminar about the relationship between tort and human rights claims, I'm sure. And so it goes on. But even in the main social dimension chapters, the labour chapter has had to be completely recast to bear in mind the growth of the employment contract-free economy, the growth of the problem of finding ways of achieving decent work, where we are battling modern slavery again. Which is quite shocking when you think about it. In the human rights chapter, of course, the most monumental change has occurred, and I'm extremely honoured to have John here today as the author of the UN Guiding Principles on Business and Human Rights, which has, I think, become the benchmark for business and human rights analysis. And while there are criticisms to be made, and of course Surya is a well-known but friendly critic of the UN GPs, we can't underestimate the importance of this change and the three-pillar approach of state duty to protect, corporate responsibility to protect, to observe, and access to remedy. No one would have thought of this 40 years ago, and certainly not at the time of the first edition. And then in the environment area, we see a much greater understanding of the emergency that faces the world and the need for corporates to play their part in reducing carbon emissions, in helping through technological developments to get to a clean global economy. But then on the other hand, we have things like Dieselgate, which I cover in the third edition, showing that corporates still have a moral battle to fight between making profits at all costs and being good corporate citizens and good environmentalists. So these are some of the themes that I've had to update, but some broader themes for discussion, perhaps. One of the things that underlies a lot of these developments is the idea of multi-stakeholder initiatives and multi-stakeholderism, which John has been very instrumental in using as part of the UNGP's process. And there's a huge utility in this process because we have stakeholders coming together and having some sovereignty over rule making, which in a way became possible because the neoliberal market state was quite happy to let things go and simply facilitate business. But who's going to control the bad bits of business? But here's a methodology, something that's evolving institutionally through things like the Kimberley Diamonds process. But there are risks, of course. There are risks that special interests and powerful corporate interests in particular may take this process over. And finally, I'm thinking about protectionism. And when the book was already in production, the editors and I decided that we really do need a postscript, because the manuscript was finished in January 2020, but then the COVID crisis broke out. And during about a year ago, when I too was suffering, I think, from COVID, I mean, the symptoms looked pretty clearly the COVID symptoms, but luckily I was not seriously ill. It took 7 weeks to get over the thing. I thought, well, we need to actually see how this is going to affect the evolution of business regulation. And UNCTAD, who James is representing today, and thank you, James, for taking the trouble to be here. I very much appreciate it because 14 years of association before my illness, and now gradually from home helping again in UNCTAD's work is a major feature of my life. But UNCTAD has done an awful lot of very useful work last year and continues to do this to actually look at how the pandemic is affecting trade and investment regulation. Now, I haven't got the time to go into the details, and I would recommend the audience to look at the UNCTAD website and UNCTAD publications on the impact of COVID on investment policy making, and also on how international investment agreements could potentially be used by investors to challenge COVID-related regulatory measures. But I'd like to just mention, by way of conclusion of my introductory contribution, in this process, where are we going to go with corporate governance and human rights? Because two things are problematic. First of all, are we seeing the end of a proper internationalism and its replacement by economic, political, and pandemic nationalism? And this is an environment where human rights don't generally flow very well. And secondly, are corporates going to see the pandemic as an excuse for saying, we haven't got time right now to worry about human rights issues because we've got bigger issues to worry about? I think John will probably say a few words about this, because there is a risk. I think his own institute has pointed out the risks involved in the current environment of ignoring human rights considerations in the regulation of business and worrying excessively about the economic dimension of rebuilding the global economy. And so we have these themes of protectionism and potential long-term threats to the realization of business and human rights goals, which I think are going to inform our debates for the future. I'll stop there. Thank you.
Thank you very much, Peter, for outlining briefly but so clearly the important updates in the new edition and also some of the debates. I'm sure that the panelists will speak about some of the issues that you identified. So we're now moving to the second author, who has contributed a new chapter in the third edition on multilateral banks, Dr. Ebbe Rogge.
Thank you very much, Ekaterina, for the introduction. Yeah, just before I kick off with the real thing that I have to say, just 2 brief points. Firstly, just a short disclaimer that I'm sitting here on behalf of Leiden University and not on any other organizations that I work for or might be affiliated with. And if anything I say here does not reflect their opinion, just my own. And the second brief point is, well, Peter, I promised I wouldn't shower you with praise, but after the introduction that Scott gave, I can't resist but reflecting just for a very short moment on that moment when I walked into your office the very first time, asking whether you would accept me as a PhD student. And look where we are now.
Yes, I'm sorry I diverted you from a richer career.
Yes, indeed, lured me away from the city or from the bar. But in any event, I'm very grateful, both to yourself and I should mention our colleague Nick Foster here as well, of course, who supervised me at the same time. And that actually leads straight on to, the fact that, yes, I did write a contribution to this book, but we should not forget, Peter, you wrote the other 16 chapters and the previous 2 editions. So I'm really, really humbled and honored to be sitting here, but I do want to put my contribution in proper perspective. Right, now to the substantive part of what I wanted to say. I'm going to briefly make 3 points. The first one will be as to why did we include this chapter in the 3rd edition of the book. The second one, I'll reflect on corporate governance at banks, which sort of is the main theme or conclusion, if you like, of the chapter. And the third element will be more forward-looking. I think Peter has already hinted sort of towards the 4th edition. I'll give some reflections of what I think might be included on the financial services field in that regard. So as to the first point, why did we include this chapter in the 3rd edition? Well, it reflects the role in the real world economy that banks actually play. If you think about the daily lives of people, if you think about just ordinary payments by way of card, if you think about getting a loan, getting a mortgage, if you think about small, medium enterprises, lending money, you quickly get to the point that financial institutions and banks in particular play a really substantial role in today's society. And that was particularly highlighted by two events or two items that I'll briefly discuss. Firstly, the crisis, and secondly, sort of the cultural elements and scandals that we've seen, or at least in the UK, which I'll focus on then. So firstly, as you all know, in 2008, we had a series of events. Lehman Brothers went bankrupt in the UK. We had Northern Rock. We had people queuing outside their offices. I still vividly remember my lunch breaks at a time where you'd walk through the city and you actually saw people standing outside those offices queuing to retrieve their savings. Of course, RBS fell over as well. And what that highlighted was the importance, which I just described, of these of banks, of financial services in the real economy, and the impact on society at large. And what we saw then was a government intervention, trying to make sure that it didn't all collapse and didn't all fall apart. And you saw recapitalization, for example, of various financial institutions. You saw introductions of terms of systemic risk and too big to fail. And all of that is because the importance that this industry plays. I referred to culture and scandals. What we also saw, apart from these banks failing, we saw, for example, payment protection insurance scandal in the UK, where retail customers were sold credit cards with all sorts of insurance elements added onto it, which they weren't told of or were not aware of. This sort of mis-selling sort of hinted towards fundamental problems in how banks had their business strategy set out, how they made money, and the cultural issues ingrained perhaps in industry. Where problems such as the libel scandal, one could still refer to, those are a few bad apples who've been trying to manipulate the libel rate. That became more difficult. More and more of these sort of situations started to emerge. Now, the book sets out, my chapter in the book sets out those events in more detail, and I'll stop here. My second point, and is towards the governance of these financial institutions. What have we seen that could be improved? And I think the very first point to make is that although this chapter deals exclusively with the bank-specific elements, almost exclusively, everything else that's in the book equally applies to them. It's quite often forgotten that general rules of corporate governance and so on also apply. Many researchers tend to focus on what makes banks different, but very simple box standard things which apply to ordinary companies equally apply to the banks. And I'll make 3 points and on corporate governance here, but the first one is very much a general one. It's about board effectiveness and board composition. What we've seen during the crisis with some of the banks that failed is that, for example, there was a very dominant CEO, or the non-executive directors had insufficient knowledge or insufficient time to make an adequate and appropriate challenge of the executive members of the CEO. And one of the additional problems was, and I think this, reflecting on how the general public responded to this crisis, is that accountability was problematic. Certain individuals were perhaps sacked or are no longer working in the industry, but certainly for the general public, they do not have appeared to have paid for it, or they haven't been punished, if that's the right word. For example, in the UK, as a result, we've seen the introduction of the senior management certification regime, which is a clear attempt to make sure that if anything like that happens again, accountability is indeed in place. The second point on governance is the role that the regulator plays in corporate governance. And we've seen, at least in the UK again, a restructuring of the then financial services authorities. Quite a few of the reports and research papers that have been written on it point to the fact that the focus was mostly on capital adequacy, and then we leave aside the fact whether those capital adequacy rules were sufficient. The point I was going to make then is that it was found that the regulator did not focus sufficiently on non-capital aspects, meaning the culture inside an organization, its business model, how does it get revenue, etc. And that's in the end saw the split of the FSA towards the Prudential Regulatory Authority and the Financial Conduct Authority. And as the name sort of suggests, that is now what they do. The third item on governance that I wanted to highlight is the issue of state ownership. And that is something that's been relatively, new or novel, but it's something that the financial crisis introduced in the West again, without any clear idea of where it would go. And we see that the state as shareholder in these banks might actually have quite a difficult position because of their confusing policy objectives. See, on the one hand, we might still be in a deep financial economic crisis. So you may want these banks to start lending to small businesses, etc., to get us out of the crisis. But at the same time, they needed to become healthy and recapitalize. And those are two conflicting objectives, because if you want to recapitalize, you need to raise capital and lower your debt exposure. So the state ownership created a lot of question marks, so to say, because of the different policy objectives there. I'll leave governance now and talk about the third and final item I wanted to talk about, and that is looking forward to the fourth edition. And I think, if you look at the EU's policy agenda on this, and if you look at the amount of research that is appearing on it, I don't, the sustainable finance question is becoming bigger and bigger. The EU's Green Deal is a very important step that's been set towards adherence and to the climate change commitments made in Paris. But it's interesting to briefly reflect already on the sort of direction of travel that the European Commission appears to have taken at the moment. Only last week, some news that was being published. The Corporate Sustainability Reporting Directive, it is now, which is a revamp of the non-financial reporting directive, is one of the, what I would say, one of the three pillars of their policy, which forces companies to disclose not just their normal financial accounts, but a lot of additional non-financial information. The taxonomy regulation, I think, goes hand in hand with that, because that then sort of says how it should be reported and makes non-financial reporting comparable, if you like. And together with that goes something like sustainability finance disclosure regulation, which asks those investing in companies, investment companies, etc., to disclose how they've then build up their portfolio, and they can do that based on the information given in the previous two. Now, the point of all that is that this appears to be based on the idea that as long as all the right information, the non-financial information, is being brought to market, and perhaps it'll get rated by ESG rating agencies, etc., then the market will do its job, and it'll sort out where it does and does not want to invest in. And the thinking, if I'm right, is that it'll become more and more difficult for those companies that are not green, so to speak, to finance themselves. Now, of course, you can question that, because at the same time, if you think about who is investing, that might, for example, be ultimately large pension funds, and of course they have their commitments as well in the end to pay out for those who are retired, and they do need to look at returns on their investments. So how all of that interplays, I think, is very interesting to watch, and something that we need to think carefully about and reflect on. I'll stop there, Katrina.
All right, thank you very much. Thank you very much for this very insightful presentation. Well, we are now ready to move to the panel discussion, and in advance of the event, Peter and I have asked our speakers to think about particular questions. So our first speaker is Professor John Ruggie, and we asked John to reflect a little bit on the broad impact of the UNGPs for the development of the field and some beyond. Please, John.
Okay, thank you. I'm thrilled to participate in this book launch, Peter. The second edition of Peter's book had biblical status for me during my mandate as special representative of the Secretary General and developing the UNGPs. As has been noted, its breadth and depth are truly extraordinary. It is a magisterial book. Peter was also a valuable contributor to the consultations that I convened, and a patient tutor when I flooded him with emails asking stupid questions, and to which he always provided smart answers and no snide remarks. Thank you, Peter. But these attributes will be familiar to all of you who know Peter. But I bet there is no one here who knows that Peter is also a seer. He is someone who literally can see the future. It's true. In a journal article published in January 2012, he predicted what would happen in the European Union in the business and human rights space in the year 2021. It's amazing, Peter. The article was published in Business Ethics Quarterly. Its title is Implementing the New UN Corporate Human Rights Framework, Implications for Corporate Law, Governance, and Regulation. For those of you who love footnotes, you can feast on 136 of them. The article, as you might have guessed from the title, addressed the implications of the UN guiding principles. Let me read you just 2 sentences from the abstract. 1, it is argued that the notion of human rights due diligence introduced and elaborated in the UNGPs, will lead to the creation of binding legal duties, and the principles of corporate and tort law can be adapted to this end, unquote. Second sentence in the abstract, the responsibility to respect, Pillar 2 of the UNGPs, involves adaptation of shareholder-based corporate governance towards a more stakeholder-oriented approach, and could lead to the development of a new stakeholder-based corporate model. The article explains why and how this evolution will take place. Peter, I certainly had hopes in 2012. You had foresight. So where are we now that we're in 2021? Well, for the first time in roughly 40 years, the social purpose of the corporation and the need to move beyond shareholder primacy are subject of mainstream discussions particularly in the Anglo-American capitalist system. ESG investing, which was a niche product until the financial crisis, now accounts for close to 40% of all assets under management globally. And it keeps rising. In several European countries, as well as the EU level, mandatory human rights due diligence legislation is being drafted or has already been adopted. At the EU level, the Sustainable Finance Disclosure Regulation requires financial market participants to disclose how they integrate ESG factors. The European Parliament adopted a draft mandatory human rights and environmental due diligence law just a couple of weeks ago by a vote of 504 to 79. And DG Justice is expected soon to release its version of mandatory due diligence, the Sustainable Corporate Governance Initiative. Both of these include liability provisions. The EU regulations, interestingly enough, are intended to apply not only to EU-based companies above a certain size, but to any such company that does significant amount of business in the internal market, which is to say, American corporate lawyers are beginning to wake up to the fact that there's a whole new bunch of regulations coming out of the European Union that will have profound impact for American investments and American banking in Europe. Each of these initiatives, interestingly, references or explicitly draws on the concept, the construct of human rights due diligence introduced in the UNGPs. Now, this is today's headline news, but Peter knew it all back in 2012. So Peter, who's going to win the 2026 World Cup?
Well, it's not going to be England, that's for sure.
Thank you very much, John, and thank you for stressing the importance of the concept of human rights due diligence, which is obviously now one of the spotlights of the whole debate. So we are moving now to Professor Barnali Choudhury, and we asked Barnali to comment a bit on the evolution of the business and human rights field from a legal perspective and trace some transformations.
Thanks, Katarina. I'm just going to share my screen. So hope that you can see that.
Yes, it works. Thank you.
Great. So thank you very much to the organizers for including me in this event. And I just want to say a couple of, or just give like a quick little story before I begin. And that is, I read Peter's book first as a student And then I came back to it, I think around 2011, when I began teaching a course on multinational enterprises and the law. And at that time, the book was still a couple of years into its publication date. So I actually looked for another text that I thought would be, more recent. However, at the time, I surveyed the entire market. And after looking at all the other books that were available, I decided that even though Peter's book was slightly out of date, there really just wasn't any comparable text to Peter's. So I am very delighted today that Peter is actually bringing a new edition of his magnum opus to all of us. Now, as Katerina mentioned, I was asked to talk about the legal transformation of the BHR movement. And I would say that the movement has really proceeded in 3 stages. So at its early stage, it worked towards establishing the norm of business responsibility for human rights, or what I would call norm shaping. So this began in the late 20th century with developing countries attempting to control the power of multinational corporations. So this led to the proposed UN draft code of conduct for transnational corporations, but which, due to friction between developed and developing countries, the code became eventually abandoned. Now, in response to these efforts, OECD countries developed their own format for regulating multinational corporations. This gave birth to the OECD Declaration on International Investment and Multinational Enterprises in 1976. Now, although the declaration contained guidelines for multinational enterprises, it actually didn't contain any specific references to human rights, although later revisions of the declaration, which are now known as the OECD Guidelines for Multinational Enterprises, did. More successful were efforts to define corporate responsibility for labor rights. This, of course, led to the ILO's tripartite declaration of principles concerning multinational enterprises and social policy. In 1998, the UN Subcommission on the Promotion and Protection of Human Rights instituted a working group to explore the activities of multinational corporations. The working group decided to draft a code of conduct for multinational enterprises that eventually became the UN norms. The norms represented the first non-voluntary initiative to detail corporate responsibility for human rights, but unfortunately, due to opposition, they were not adopted by the UN. Nevertheless, the UN continued to act in this field, ultimately creating the Global Compact, a policy initiative that advocated good corporate practices in several areas, including human rights. The Global Compact was applauded by business, but derided by its critics for its non-binding nature. So given the problems with the UN norms and the shortcomings of the Global Compact, the UN continued to explore what the international community expects of business in relation to human rights. This led to the appointment of Professor Ruggie to clarify the standards of corporate responsibility and accountability in relation to human rights. So this brings us to what I would call the second stage in the legal transformation of the BHR movement, or what I will call norm crystallization. So as we all know, Professor Ruggie drafted the Protect, Respect, and Remedy framework, which advocated that responsibility for business and human rights issues should rest on 3 different but complementary pillars: the state duty to protect, the corporate responsibility to respect human rights, and the need for more effective remedies. He then elaborated upon the framework's 3 pillars in the UN Guiding Principles on Business and Human Rights. And the UNGPs, I would argue, established or crystallized the norm of the corporate responsibility for human rights. So it's now well accepted that corporations have a responsibility to respect human rights. The norm has been incorporated by several international instruments, such as the OECD Guidelines and the UN Global Compact. It's been embraced by the UN Committee on Economic, Social, and Cultural Rights. It's been adopted by international financial institutions, and it's even managed to infiltrate some free trade agreements and international investment agreements. So that brings us to what I would call the third stage of the BHR movement, or enforcement. Now, the UNGPs, as we all know, were couched strictly in soft law terms, relying on an expectation that corporations would adhere to their responsibilities. However, we've probably now entered the phase where the corporate responsibility to respect human rights is slowly making its way into hard law by becoming more precise in its content and by becoming an enforceable norm. At the international level, as we all know, several states are drafting a business and human rights treaty, which may eventually establish binding legal obligations for businesses for human rights. At the domestic level, as we've already heard from some of the other speakers, several countries are involved in drafting due diligence laws that will hold domestic corporations liable in national courts for harms to human rights or the environment. So France's devoir de vigilance is already being used to hold French water giant Total liable for harms in Uganda. And with several other states, such as Germany and the Netherlands, in addition to, of course, the EU, drafting similar legislation, the legal consequences for corporate failure to respect human rights is becoming formalized, at least in Europe. Several courts are also paving the way to establishing liability for corporations for human rights and environmental harms. So in January of this year, the UK Supreme Court reaffirmed the notion of corporate responsibility for environmental damage in the case that Peter already referred to, Okpabi and Shell. And Okpabi follows on the heels of Lungau and Vedanta, where the UK Supreme Court previously allowed claims against a corporation for similar harms. Now, the parties in Lungau settled the claim out of court, but the Dutch courts, actually relying on Lungau, found the corporation liable for Nigerian farmers and Shell for facts that were relatively similar to Lungau. The UK Court of Appeal has also recently allowed a claim brought by the wife of a shipyard worker against a corporation for the part that they allegedly played in his death. So in Begum and Moran, the court chastised the corporation for sending its ship to be dismantled in a practice that is inherently dangerous and likely caused the worker's death. The case will now proceed to trial. In Canada, the Supreme Court has recently also held that corporations can at least theoretically be liable for human rights violations, since, according to the court, customary international law, which encapsulates several international human rights norms, can bind corporations. The case Nevsin Resources versus Araya has been settled out of court, but corporations in Canada face similar trials in Garcia and Tahoe Resources and Chalk and Hudbay Minerals, in which courts will determine the potential liability for corporations for human rights violations as well. So what do I see when I'm looking ahead to the future? Well, I expect that the BHR movement will continue to evolve, moving to increase corporate accountability for human rights. And this continued evolution will be informed by wider developments in society. So first, we've already heard Professor Ruggie allude to this, but there will be a greater push from society to lessen the norm of shareholder wealth maximization. So statements from large American CEOs in the Business Roundtable, as well as at the World Economic Forum, formally recognized the importance of stakeholders. And this will shape society's expectations of business, even if the companies themselves are not serious about their commitments. Second, there will be an increased interest by investors in ESG investments. And this will drive corporations, if for no other reason than for financial reasons, towards environmental and social issues. Third, there will be increased attention to issues of sustainability generally, and the importance of the Sustainable Development Goals will also push governments to limit the activities of corporations, including in relation to human rights. And finally, as COVID has already highlighted, the increasing inequality of society will at one point simply become intolerable. So ensuring that corporations respect human rights will be one part of the effort in reducing inequality. So thanks very much.
Thank you very much, Barnali, and thank you for outlining these milestones and referencing key developments. Our next speaker is Professor Surya Deva, and we asked Surya to approach the discussion in the context of the access to justice considerations and to reflect a little bit on these issues. Thank you.
Thanks, Katya, and let me start by congratulating Peter for a comprehensive, insightful, and I would say contextual book because the way he treats the term law in his book That is very different from how many lawyers may approach the concept of law. It's really a privilege and honor to speak and share some remarks for two reasons. First of all, when I started doing my research in this field, this book was only some of the handful of books that I could start researching about. And the second fact, which many people may not know, is that Peter was one of my external examiners of the doctoral thesis long time back. So Peter, is wonderful to be part of the journey with you in different ways. So let me start with why Bhopal. And I think I would give three reasons why the Bhopal gas disaster provides an interesting case study even in 2021 to test the progress that we have made in the last 37 years. First is a personal region. I started researching about business and human rights in the year 2000 by an accident. And the accident was that I got a teaching position in a city called Bhopal itself. And that triggered my interest from constitutional law to business and human rights. So that is a personal reason why I consider Bhopal to be that silent case study. The second is that Bhopal presents almost all of the governance challenges or regulatory challenges that we have in the past. And I think it provides a good way to test what progress we have made. And the third is that Peter's, one of the landmark papers or early papers in the Modern Law Review in 1987 was in fact on Bhopal litigation. And in his book, including in the third edition, Peter touches upon the Bhopal case study in several chapters, including in the context of forum non-convenience, the liability of the parent company for the violations by the subsidiary. For these three reasons, I think Bhopal presents as a good case study even in 2021. So what I would like to do is, I would like to pick 5 variables to test the progress. And I'm going to prepare a scorecard. And let us see how many points we get out of 5. So 5 variables and 1 point for each of those variables. The first variable I would like to focus is human rights responsibility of business. If you look at the Bhopal literature in 1990s, mid 80s onwards, most of the literature talked about Bhopal as a mass tort or as an environmental pollution case. There is hardly any literature in the 90s or even in the early 21st century, which treated Bhopal as a human rights abuse or a human rights violation case study. And I think this is despite the fact that if you look at the language of the 1983, the Code of Conduct, which Barnali referred, there was a reference to human rights in the 1983 draft code. This is just 1 year before the Bhopal gas disaster. And of course, the ILO declaration of 1977 also made a reference to UDHR. So despite those very minor references to human rights, the analysis of Bhopal has not been in relation to human rights. And I think that is something which has been changed by the UN Guiding Principles. I think many things have been changed by the UN Guiding Principles, but for me, the most crucial is that this is not a matter of debate anymore, at least in the public domain, that businesses do not have human rights responsibilities. To me, that is the most crucial element. So, and because of this, I think now it is very clear that the cases like Bhopal can be analyzed as a situation of human rights abuse, not merely a mass tort or environmental tort cases. Of course, because of these reasons, I would give it a score of 1 out of 1, because now that landmark has definitely shifted. And of course, other roles have been played, whether it is evolution of the tort law or mandatory human rights due diligence, which can be seen as triggered by guiding principles, but I can also argue it is because of the failure of the Pillar 2 in itself. And that's why Pillar 1 is coming to the rescue of Pillar 2. So I think we can also see it in this way. Let me move on to the second variable. And the second variable is the parent company's liability. Because a key issue in the Bhopal case was, can the Union Carbide Corporation, the US parent company, be held accountable for this gas disaster in India? The Indian government pleaded many principles, including the enterprise principle and the strict or absolute liability for indulging in hazardous activity. And Peter's article, as well as his book, he masterly analyzes those judgments and cases and all this. In my view, as far as this variable is concerned, the progress has almost not been there. So if Bhopal happens today in 2021, the enterprise principle is not going to help much. If we try to apply the strict liability, again, I have my doubts that that is going to hold the parent company like UNCTAD accountable. Some hope is though provided by the cases like Vedanta and Okpabi, but I will be very cautious here. And my caution is because we should not over celebrate these cases, because these are individual cases based on specific facts. They are not laying down a principle that a parent company is responsible or accountable for the every abuse which could be connected with the subsidiary or the supply chain. Let us be very careful here. So I think we should not be celebrating Vedanta and Okpabi. How many victims can approach the UK Supreme Court? How many cases LEADE can take forward? Mandatory human rights due diligence could be a game changer and could also fix this issue of parent liability if it is drafted properly. So again, I will be cautious here. And because of this caution, I will give it maximum half a point in relation to that. Now, the third variable is the forum non-convenience. Now, a key obstacle, if you want to target the parent companies, is the doctrine of forum non-convenience. That was the hurdle that the victims in Bhopal case failed. And I think there has been no progress. If the Union Carbide has to be sued in the US, no difference. The same obstacles will be presented. And in fact, it is more regressive now, because even the Alien Tort statutes is not as potent as it was in 1990s onwards, right? And because ATS was also used by the Bhopal victims. So even that did not happen. That did not provide any positive remedy. Of course, there are positive developments in European Union. And I don't have the time to go into that. And the cases that Barnali mentioned, let us say in UK and Canada. And because of those fragmented positive developments, I would say, I'm willing to give it half a point for this third variable. Otherwise, if it is Bhopal case in particular, no progress and it will get a 0. Let me start with the fourth point, fourth variable, which is the actual remedy. And I think many people make a mistake in comparing effective remedial mechanism and effective remedy. Effective outcome is very different from having an effective mechanism. So I'm here looking at whether you get effective remedy as an outcome or not. Now, what did victims get in Bhopal? They got compensation, but the company never admitted liability. There was no apology, nothing. No liability was admitted. The settlement was not confidential. The criminal sanctions, there is a long journey on that, but the most recent thing is that in 2010, a court in India sentenced 7 executives for 2 years of imprisonment, but imprisonment was suspended. So they never suffered anything till now, and the appeal is pending. Now, if that happens again now, I don't think anything has changed on that in getting actual remedy. Let us look at, forget about Bhopal for a second. Let us look at the Vedanta case. So the victims got compensation in 2021, January. Agreement is confidential, no apology, no admission of liability. So from Bhopal to Vedanta, what had changed? Nothing, and I will give it for 0 in terms of the actual remedy that the victims in a case like Bhopal are likely to get now in 2021. My last point is state accountability. Because in the Bhopal case, something which we don't discuss enough is the liability or the responsibility of the Indian government as well as the state government there. I visited Bhopal city 4 years back. So the plant site is still polluted. And the kids have broken the wall and they play cricket in this toxic site. So site is still there. The government is not doing anything. And people are just looking at this. So of course, the liability of the government was a major issue in that time. And I very much doubt anything had changed until now in the last 37 years. So how do we hold the governments accountable in those particular cases when they, because of corruption or because of their nexus with the businesses, they allow these licenses and factories to operate? And we can look at number of disasters that have taken place. Whether it's Rana Plaza, is a Kick factory fire in Pakistan, the Lao dam breach. So there are numerous examples, or in Brazil, there are numerous examples all over the world in more recent years where similar accidents are taking place and no liability or accountability of the government. So again, I would give it 0. So basically, out of these 5 variables, the total score is 2 out of 5, which is to 40%. I don't know about the other institutions, but 40% is not really regarded progress or doing well at my university. Let me end with 2 final points, which are more going beyond Bhopal now and looking at the picture. I think polycentric governance is the way to go forward. There is no doubt about it. We can frame it differently. I call it integrated theory of regulation, but whatever we call it, that is the way to go forward. I think there is hardly any disagreement on many scholars and activists on that. At the same time, the struggle that I have is this: what do we do when states fail to do what they should be doing? What happens when Pillar 1 fails? What happens when states turn authoritarian? I'm sitting in Asia. I come from India. I'm based in China. That is about 1/3 of the world population. How do we ensure that China and India at the government level uphold Pillar 1? Can the polycentric governance save Pillar 1? I have my serious doubts. So unless we solve this issue of non-action on the part of the government, other actors can only supplement. But unless the governments act, I think I have my serious doubts that things will change dramatically. I'm not dismissing the relevance of other actors, minded. But what I'm saying is, when states are failing, how much can that gap be rescued and filled by other actors? And I think that is where the civil society I see is a ray of hope. The progress that we have seen, whether it is about the mandatory human rights due diligence, it is not because of the UNGPs, it is because of civil society pressure. The treaty process, again, civil society is there. If you look at the civil society, and I think John and I may have different views on this, because there is no pillar for civil society in the UNGPs. Of course, he thinks that Pillar 3 is for civil society and civil governance. But I think civil society has contributed to the substantial progress so far, in my view, in the last 10 years. Can they continue to do that? It will depend upon whether the governments allow them, because civic space is really shrinking in many parts of the world, including in a city where I'm sitting now. So thank you very much. Once again, I will stop here.
Thank you very much, Surya, for making your presentation also so interactive. And it's clear that there have been several important developments on the level of case law, but it's also clear that a lot remains to be done. Well, we are now moving to our next speaker, Rae Lindsay, and we asked Rae to share some insight from the point of practitioner and talk a little bit about the regulatory challenges and opportunities that exist in the current landscape. Thank you.
Thank you. And I must say, if I had any thunder to my presentation, I think a lot of it's already been stolen. So with respect to things like mandatory human rights due diligence and parent company liability, some very expert remarks already. And I'm also in some trepidation in saying anything about the UN guiding principles when John is present, because he's been known to put lawyers in their place in the past. But I'm delighted to be part of this discussion. And it's clear from everything that's been said so far, and certainly from my experience as a practitioner, that Peter's book, with Ebbe's excellent contribution, should be mandatory reading for anyone who is or aspires to be a so-called business and human rights lawyer. And I think we are a growing breed. I've had the pleasure of practicing in this area for about 20 years now. And so the presentation is based on my personal perspective developed over that time, certainly not the views of my firm or any of my clients. And the starting point of that for me was as an international lawyer involved in litigation. And I have to say that I have to agree with Surya that sadly, with respect to where has human rights litigation reached, and access to remedy for victims of business-related human rights harms, I don't think there has been a great deal of process, and we can come back to that later, because I think certainly also Peter's visionary imagination that due diligence would develop into a legal duty of care that would either be reflected in case law or in statute. There's been no huge evolution to that point as yet that's been adjudicated in the courts or resulted in greater access to remedy or findings of liability in court cases, notwithstanding the cases that have been referenced. I think certainly as time goes on, again, within the case law context, that's something that could evolve and change. In recent cases in the United Kingdom, although the court didn't address these issues because they were raised in third-party interventions, it has been argued, for example, that the guiding principles and the concept of due diligence and enterprise-wide due diligence should be taken as indicating the existence of a duty of care by a parent for the entire the activities of the entire enterprise, and not just the existence of the duty of care, but also the standard of care. And that was argued to exist because of the international universal acceptance and uptake of the UN guiding principles, and the fact that governments do now expect businesses to operate in accordance with the guiding principles. So the seeds of that is there, I think, for future uptake in litigation. But we have to, I think, consider, as Surya has pointed out, whether there is enough progress that can be made in the context of particularly transnational tort type litigation, whether that's the appropriate vehicle for access to remedy in these kinds of cases, and whether more needs to be done in that regard to change the landscape. And that is part of what's happening at the policy level, I think, with respect to, since, for example, the Council of Europe's recommendations in 2016-17, and that are reflected in the European Parliament's considerations around the mandatory human rights due diligence laws, whether there needs to be some expansion of jurisdiction within member states to allow for parent companies to be sued in those courts for activities that take place elsewhere. But that's just part of the picture. But I do think, what we're seeing in this area is a coalescence of policy focus on the issues of mandatory human rights due diligence on the one hand, and what are the obstacles to remedy on the other, and how do states ensure that there is sufficient access for victims of business-related harms. On that second one, I think there is a question of something else that Surya touched on, which is, states' duties to protect human rights, and again, whether creating access to remedy in the home state of a corporation is going to actually address some of the capacity and other issues in host states, for example, where there may not be sufficient protection of human rights or access to remedy there as well. Now, just another observation as a practitioner in this area is Peter's very key identification of the interdisciplinary nature of the field, and we are all not just business and human rights lawyers having to take account of the broad spectrum of corporate governance and other issues, all of which are addressed in Peter's book. And I have to say, we all owe a debt of gratitude, not just to Peter, but also to John for the forensic analysis of some of the key concepts on which the three-pillar framework and the guiding principles are built, and dealing with these issues around how to regulate multinational business enterprises in an appropriate way and address their impacts on human rights. A lot has been said about the move towards mandatory human rights due diligence, and certainly I think since the since the UN Guiding Principles were endorsed by the Human Rights Council in 2011, there has been an evolution of regulatory measures to seek to address certain business and human rights issues. The first tool of choice being, reporting type requirements, but then a recognition that although reporting would incentivize due diligence, that things weren't moving fast enough. And so now this coalescence, as I say, around the idea that mandatory human rights due diligence is the way forward, and that seems to be now being embraced by individual states and also by the EU. In this area, obviously, the concept of human rights due diligence in the UN Guiding Principles is a really effective governance tool to create processes for businesses to identify and address human rights impacts, including a decision-making framework whereby businesses identify the nature of their involvement with an impact and are supposed to act in accordance with that in order to address their impacts. As the Office of the High Commissioner usefully indicated in its issues paper last summer, it is possible, of course, and this was always envisaged by the Guiding Principles, to use law to compel companies to take proactive steps to go through the process of human rights due diligence. But when it comes to translating those ideas into a legally binding regime, there are many very different variants. So people can mention mandatory human rights due diligence, be talking about many different things. And so how the concept is encapsulated into domestic legal regimes is obviously key as to how it will operate in practice. I think that's one of the key challenges here. Although we have we've got an idea of what the EU has in mind through what the Commission has said in its consultation process and what the Parliament has input into the process. There are details that remain very unclear, and to me, there are parts, and going back to what was said in an earlier presentation, it's not obvious that the liability regimes that will be established will necessarily give rise to access to victims of business-related human rights harms to make claims against companies, as opposed to the establishment of due diligence processes and the possibility to challenge whether those processes are adequate, as opposed to creating claims related to the harms that might result if they are not. So that obviously has to be given some coherence. I think the most challenging area in which to try and address this in terms of putting the concepts into practice in laws arises in supply chain contexts. Now, obviously, one of the beauties of the Guiding Principles was its efforts to regulate multinational business through various tiers of supply chains. And in that context, identifying responsibilities when businesses are linked through their operations, products and services to an adverse human rights impact that's actually caused or by a third party. It's in that sphere that I can see real difficulties in encapsulating appropriately where the legal duties and liabilities may lie for, say, a home company in a European state under that regime, with respect to impacts that occur in several tiers down the supply chain. Because at the moment, there are no legal duties requiring companies to take steps to address those harms. And so it's done in a voluntary way, obviously with the expectations under the UN Guiding Principles. And if there is to be some mechanism whereby impacted persons should have recourse through that supply chain, that's going to involve an expansion of existing legal duties, and that'll have to be very carefully done so as not to undermine the benefits of human rights due diligence when it's undertaken in accordance with the Guiding Principles, which includes companies through the use of leverage grappling with really difficult human rights impacts and seeking to resolve them. And on that point, I suppose one of the concerns I think of business, and many businesses are very much in favor of the idea of mandatory human rights due diligence in order to create a more level playing field and some sort of clarity around legal expectations. But I think a concern around the sort of privatization of the protection of human rights and what the role of business is in that context, and particularly in states where there are endemic and systemic human rights issues. Before I wrap up, I'd just like to say, I think one of the, I think the human rights due diligence concept as encapsulated within the UN Guiding Principles, obviously has been a key feature and one that resonates now across the spectrum of business activity. And so the Guiding Principles obviously now reflect the due diligence aspects reflected within the OECD guidelines, so that due diligence approach is now applicable across all areas of responsible business conduct that's covered in the OECD guidelines. And so the idea of identifying potential adverse impacts and addressing them in appropriate ways and being accountable and reporting, etc., applied across that spectrum. And that's gained real traction, and the guiding principles in the OECD guidelines are very much reflected in and stated to be part of the foundation of the EU's proposals with respect to mandatory human rights due diligence, and also in the other sustainable finance reporting initiatives that were mentioned by Ebbe. And so I think really key that those concepts are a cornerstone, a foundation for a lot of the regulatory activity that's taking place. And I think that helps give them a great deal of coherence. On that, the fact that the business and human rights aspect is now the part of S that is ESG, and the resonance that has across the board, which has moved, I think, an acceptance of these imperatives around the responsibility to respect business and human rights beyond the more obvious sectors, the extractives and manufacturing and retail, and into the financial sector. So ESG and investing in particular, driving different behaviors through expectations on companies and a sort of circular effect through companies and back into finance. And that's really key. I think the UN Guiding Principles, even though they are they're a basis on which to identify and address adverse impacts, because of the attractions of the due diligence process, have the potential to be a platform also to build on as a framework that will help companies now take forward sustainability agendas, which involve not only identifying and addressing adverse impacts, but also supporting their positive agenda to drive forward initiatives that are intended to also create beneficial outcomes. And I think, again, that's part and parcel of the EU's agenda around harnessing the human rights aspects and the due diligence within, bringing together and giving some coherence to the environmental as well as the social, and what will be needed to create sustainable transformations in ways that address, the climate emergency, as well as taking account of the social risks. And I'm sure those are issues that John Morrison will take up. Thank you.
Thank you very much for these very important observations, and I think all of them could become a subject of a separate comprehensive talk. Thank you for that. Yes, and we're now moving to John Morrison, who will reflect on the drivers and some opportunities for business and human rights scholarship and practice over the next decade. Thank you.
Great, thank you. Good afternoon, everybody. Peter, a real privilege to be on the panel. Your work, you and your work has been really very much a North Star to many of us who've meandered, and I certainly have meandered over the past 20, 30 years, from NGOs to business to working with government and IGOs in this space. Also had the privilege of employing some of your former students. I think the legacy of your work lives very strongly with your students, right? Of which there are many. Yes, I'll try and pick up maybe 3 opportunities and 1 basket of drivers. But actually one of the opportunities isn't an opportunity, it's more of a hazard. And I'll do that one first, get the negative one out the way first. And Peter, you mentioned over the next 10 years, your worry about the sort of end of proper internationalism and what that does to human rights. And indeed, we're seeing the weaponization of human rights and to some extent the weaponization of business and human rights, not least in trade. I think those of us who were hoping that there would be some Doha round type advance at the World Trade Organization are probably not going to see that as China and US step up the trade war and human rights gets weaponized within that. We might well see more bilateral trade agreements, including human rights, and hopefully around issues like data and carbon and not the sort of traditional safeguards. Again, there's a lack of good evidence out there as to how effective human rights in bilateral trade agreements really is. There's some evidence of that. But countries like my own, the UK, will happily sign agreements with Cameroon, which it just did recently, a country in civil war, and not do any human rights due diligence at all. So it's an uncertain space. Some very tough choices. We have a centre in Myanmar, the Myanmar Centre for Responsible Business with the Danish Institute, as many of you know, with 17 staff. It's not easy to understand how you apply business and human rights to concrete situations like that. Magnitsky type sanctions are easy, I think, to agree with. The removal of GSP, a much more difficult decision, I would say. 600,000 women employed in the apparel sector near Yangon. Up until 10 years ago, many of them had to migrate or get trafficked to Malaysia to work. What is the right outcome from a business and human rights perspective? Should we wind up the centre? Should we keep it going? That's a current issue for us. I think this weaponization of business and human rights will probably not play well into the UN treaty discussions around business and human rights in Geneva. Maybe I'm wrong in that assumption. I noticed China beginning to step out of the process a little bit, or at least play the long game as the European Union comes in, and of course the US is not involved. But let's see. So I think that's the sort of the bad news bit. The next point I want to make is a more positive one. Others have already made it, John Ruggie amongst them, as the rise of ESG, lifting all boats, and the S in ESG. I think this is going to help us link business and human rights to those other issues like corruption, but particularly climate and other environmental issues. And there is a lot of space for business and human rights in the UNGPs within those issues. The climate justice movement is all about remedy. And so, in terms of human rights impacts, you're already seeing, whether it be Greta Thunberg or whoever, will invoke human rights and human rights treaties in relation to remedies, in relation to the effects of climate. But also, as Rae indicated at the end of her words, the issue of just transition. For me, business and human rights and the UNGPs fits like a hand in a glove when you think about the issues of transitioning in and transitioning out of, out of high carbon and into lower carbon sectors, and also transitions around the effects of climate change and adaptation and resilience. The UNGPs, I think, is perfect there when we talk about not just workers and jobs, but we also think about impacted communities. Very difficult choices, I think, to be made. A lot of resistance, I think, from some to take the just transition space beyond jobs to the wider business and human rights framing, but I think we're getting there, and I think that will come. Also, built environment is another area where I'm seeing business and human rights emerge, and that brings back into focus economic, social and cultural rights, which perhaps have been a bit of the Cinderella from the business and human rights movement over the past decade. With the exception of water, perhaps, has been one of the areas where there has been some progress. The next point, which I think is an opportunity, a more positive one too, well, it's kind of a blend between frustration and perhaps positive opportunity, is the alignment of business and human rights and development. I mean, many of us have had lots of conversations around what it would take to really align business and human rights under the SDGs. And I say that noting there's only 9 more years of SDGs left, so probably the day before the SDGs finish is the day that we'll achieve it. But more concretely, if we take an issue like living wage, the first ever session that my institute did in 2009 was on the living wage. Because business and human rights, why wouldn't you start at the living wage? I mean, I think the ILO felt that way after the First World War in its founding statutes. But there's no ILO convention on the living wage. There's very little activity or improvement that has happened. However, I think Unilever's statement on intent around living wage in the supply chain is very important. Some other companies, I mean, a handful of companies, and I'd say no North American companies, but a handful of European companies are serious about what it might take to drive living wage through global supply chains. I don't mean in their own workplaces, I mean in the workplaces of others. That would make a big difference, I think, because it speaks to inequality. It speaks actually to a bit of the anti-globalization sentiment around big business. And maybe that will become more of a pre-qualification issue. I mean, why should anyone listen to business on business and human rights if it's tolerating poverty in its supply chains, and in some cases taking advantage of poverty in terms of economic cost? So I kind of feel that the living wage issue is coming back, living wage in the supply chain issue. And finally then, other trends. A mandatory human rights due diligence has been covered well. I think it does matter a lot what it looks like. A report on the Loi de Vigilance in France, looking at 103 companies, suggests that actually for many of those companies, it's a bit of a box ticking exercise. It hasn't really gotten into the boardrooms or even the executive committees. Companies are not seeing it strategically. And so, you know, wherever the EU goes on this, and we very much hope it will, and other governments will follow, the issue of board oversight is really important, I think. I think, therefore, I'd like to see more movement on remedy and on trade, but I think those are going to be more difficult at the global level, but let's see. Corporate governance, though, I think is one area where we will see it. The Rio Tinto cock-up, I can't think of another word for it, really, sorry about the language. I could have said worse things, actually. In the Yukon Gorge in Pilbara, Australia, is, I think, perhaps the first incident, or the most, you know, the most recent incident where a CEO and board members have lost their jobs, and no one died. You know, this is a breach of cultural rights that was so grave, a 46,000-year-old site, that it, you know, has resulted in the company reformulating the way that its governance is going to work. So board culture and board skills and legal requirements for boards to think above the short term and the financial, I think, will come. And that's a corporate law issue, I understand, and not so much a administrative law or torts law issue. But there are other drivers, and I think the issue of access to finance has been mentioned several times. Perhaps access to finance will end up being a stronger driver than legal. The law itself, we'll see, by which I mean development finance, impact investment, private finance, export credit, all the flows. And I'll finish just saying, you know, some of us have been working in the world of sport over recent years, and there is no better issue than sports if we can get human rights and the business and human rights approach into the grassroots of sport globally to begin to bring public attention to what this means and the non-state direct responsibilities of non-state actors, including sports organizations globally. And the work of the Centre for Sport and Human Rights and others, I think, will deepen and progress, and gradually the IOC begins to move in this direction too. Of course, a lot hangs on the Beijing Winter Olympics, as we all know. But I'll stop there. There's just a few reflections. Thank you.
Thank you very much, John, for identifying this trend. The Institute for Human Rights and Business is doing a great job by picking top 10 business and human rights issues annually. And it's a very helpful exercise. So thanks for that as well. And we are moving to our last panelist, Dr. James Zhan, who will talk a little bit about the relationship between business, poverty reduction and development. And Peter has already noted COVID as a main challenge, and UNCTAD's great work in that area. So we're looking forward to hearing from you, James.
Thank you. First of all, Peter, great congratulations for this monster you have produced. It is awful to read, but joyful to consult. I think it should be on our bookshelf all the time anyway, as we use your previous edition. I think now I understand why you have been hiding from us over the past few years. You have been producing this. You mentioned that you enjoyed that working together with us. That was the time you were in Geneva, but also that I even flew to your place to craft some language and a chapter in a major negotiations between a major group of countries and a major country. That was coincide with the football games. So I couldn't tell that your ups and downs of the emotion was due to the difficulties of the staff or due to the kind of a football game results. But indeed, congratulations for this new book. Now you asked me to discuss this business poverty reduction and development. I would highlight challenges, opportunities. I think there, throughout the discussion here and elsewhere, what I found that there are two basic issues we need to address with regard to investment and development. One is contribution. The other is responsibility. So when we talk about the firms, multinationals, responsibility has been addressed. I think we have the guru here, Professor John Ruggie, in this field. And that part has been addressed. And for UNCTAD, we've been taking two kind of approaches aside from the general work. One is through the stock exchange, which is the platform of the financing for sustainable development and also for ESG. So we initiated in 2009 together with Global Compact PRI on this Sustainable Stock Exchange Initiative. Now after this 11 years, we're 12 years, we have got almost all the stock exchanges on board. They all put in writing their commitment for promoting ESG to their listing companies worldwide through the exchanges platforms. So that is what we are still doing, and deepening that, pushing for mandatory listing requirements and mandatory disclosure. So that's a very pragmatic part. The second is our recent launch of family business for sustainable development, reaching out to tens of thousands of private firms which are not listed and worldwide, and that's through the Family Business Network International. So we work together and then put on the website the pledge by the family business on promoting SDGs. And that has been going on very well. We already have several hundred companies, private family business, openly committed to that, and we'll have reporting online to follow with our kind of performance indicators. And there are 43 such indicators in light of the SDGs and its targets. That's one side we think about ESG and the responsibility aspect. Here, I wish to talk more about this contribution part. As you mentioned, Peter, from the very beginning, quoting us that FDI declined by over 40% last year, and we expect another 5 to 10% of decline this year. We also monitor the progress of investing in SDGs at the request of UN General Assembly in its resolution. Our latest SDG investment monitor shows that investment in SDG sectors has declined by over 30%. In some of the SDG sectors, it was even 60 to 70%. And overall, this kind of decline the pandemic has undone, or more than undone, the progress made in investment in SDGs. since 2015, the year that SDG were adopted. So in fact, that's a very serious concern we have. And in 2014, before the adoption of the SDGs, we were asked to assess the investment gap, and we came up with this number, $2.5 trillion annually for developing countries alone. And now we see the gap is widening. So now, is this simply the issue of availability of funds? No, it is not. I'm not talking about a large pool of financial assets that in hundreds of trillions of US dollars. I'm talking about the rapid growth of sustainability themed funds, bonds, and all these financial assets now geared towards sustainable development. And last year there was $1.4 trillion of the available funds for sustainable development investment. That includes $260 billion of green bonds and $110 billion of social bonds and the $900 billion sustainable development themed funds, the funds dedicated for sustainable development. I'm not talking about $29 trillion of the investment funds that has gone through the kind of ESG due diligence. That's the responsibility part. I'm talking about funds dedicated for this contribution. It is there, but then over 90% of such funds are lodged in developed countries, still in developed countries, and invested mainly in renewable. So little funds move across to the south, landed in the SDG sectors. That's the big challenge we have. And in terms of policies, in terms of laws, there are challenges. I'll give you 3 examples. First, we reviewed 150 countries' SDG implementation strategies, of their national development strategies. In those papers and documents, few countries have factored SDG investment plans into it. We also reviewed 110 national investment laws and regulations, which we have the database. Again, few countries have mainstreamed SDGs into their national laws and regulations. So there's a need for double embedding the investment strategies, promotion strategies into SDG strategies, and embedding SDGs into investment promotion strategies. Secondly, if you look, I mean, this is the fact you all know. This is 3,400 investment treaties concluded at bilateral, regional, sub-regional levels over the years. Over 90% of these treaties predate SDG. And the majority of treaties, we have the engine to search through a database. They do not have the words of sustainable development in it, not to mention specific provisions to promote sustainable development. That's another challenge. So, and we advocated reform since 2012, and still there are 2,800 of bilateral investment treaties not being reformed yet. The bits still bite. The bits bite, particularly at this stage. So we try to come up with this accelerator for reform of international investment regime. Still, the task is daunting. The third challenge, for SDG sectors, these are sensitive sectors for private sector investment. So if you look at SDG sectors and look at the regulatory framework, the laws and regulations of countries, most of the SDG sectors are not open to private investment, domestic and foreign. Of course, we understand that this is sensitivity, that government has the responsibility to ensure that goods and services provided by multinationals and by private sector that have to be affordable and accessible by the poor. But then there's a question of a balancing trade-off, and that is the challenge for government: how to use the incentives, how to regulate the price, and how to avoid monopoly. All these things are interwoven, and that's very challenging for countries to attract private sector or to channel private investment into the SDGs. So this is the kind of a daunting task we see. And another one, of course, is a capacity issue that for most of the countries, the investment promotion agency, they all have investment promotion agencies, but they have no capacity of building pipeline bankable projects in the SDG sectors. So international collaboration is critical for that. Overall, I see, Peter, in your book, as I said, I cannot read it. I can only try to find out the chapters. You do have the investment promotion incentive, all these parts, liberalization, while having the regulation and the responsibility part. I think that part is worth the attention, and that part will be very useful for policymakers in addressing the challenges I've highlighted in mobilizing investment, channeling them into SDG sectors, and to ensure it generates positive impact and to minimize the negative effects. So thank you very much, and thanks, Peter, for your latest contribution.
Thank you very much, James, for this very insightful presentation. Well, we don't have much time. I can see that we have several questions, and thank you to the speakers for typing some answers. What we're going to do now is we're going to wrap up our talk, and I will give 1-2 minutes, probably 1 minute, to each panelist to provide some final remarks. Professor Ruggie said that several years ago, Peter has foreseen what will happen in 2021. So let's predict what is going to happen in 10 years' time, let's say, when we are going to celebrate the next edition of this book. So are we going to have a comprehensive framework? Are we going to have a treaty? Will human rights due diligence legislation provide some meaningful accountability? So I'm giving 1 minute to each panelist, and we're going to start with Peter. Thank you.
Right. Well, I don't think I was a seer in 2012. I think the seeds of all that foresight were already sown in the structure and content of the UNGPs, which have an ingenuity about them because they combine both legal and managerial methodologies. And I think that if we're going to get very far, we have to actually realize this is a multidisciplinary and multifaceted process. But those are the mechanics, the politics. Who can tell where we're going to go? We have a massively damaged economy because of the COVID crisis, which hasn't yet finished. And I'd like everyone to spare a thought at the moment for the tragedy that's unfolding on the Indian subcontinent. How that will impact on the future of business and human rights or investment promotion or sustainable development is anybody's guess. What we hope for is governments that care about the public interest, but unfortunately we see the private interest of governments being the dominant thesis in many countries. And in that sort of environment, one has to be somewhat pessimistic. But I'm hoping that there are certain trends, at least in understanding the role of corporations in society, which mean that the corporation cannot hide behind its privacy anymore. It is a public institution, whether it likes it or not. Ultimately, Berlian Means and Walter Rathenau were right. And they were right over nearly 100 years or over 100 years ago. And we need to have some kind of return to a constitutionalized approach to corporate regulation and behavior. but that takes politics and political will. And certainly in my country at the moment, politicians just aren't grappling with these questions because they've got much sillier things to worry about, like the color of their living rooms. So what can I say? I only hope I'll be around in 10 years' time to see things. But I can also say I've taken about 8 pages of notes this afternoon, and I think the 4th edition of the book starts here, and hopefully we won't have to wait 10 years for the next one. And I hope all of you will actively help me in drafting that new edition. And perhaps between us all, we might actually figure out some answers that politicians will find useful.
Thank you very much, Peter. Ebbe.
Thank you very much, Ekaterina. And well, what can I add to that, Peter? Well, let me then take a slightly more positive view, in the sense that, like my thesis, never let a good crisis go to waste. It always proves to be the sort of moment that spurs policymakers into action, and one can only hope that lessons, as you quite rightly point out already, from this COVID crisis are being taken to heart. And when you see the sort of research appearing at the moment about revisiting again discussions about purpose of cooperation, etc., then I think that in combination with the timing of initiatives like I highlighted by the European Commission on sustainable finance, on ESG, I think that might actually trigger some sort of rethink, and let's be positive on that. I'll leave it there for the moment.
Thank you very much. Professor Ruggie? I think you're...
Sorry. Just a few concluding thoughts on my part. I think if we look at the trends in the Anglo-American world in particular, where the idea of sort of shareholder primacy emerged in the 1980s and was internationalized through the international financial institutions, American foreign policy, British foreign policy, et cetera, et cetera. I think we're at the end of that era. Shareholder primacy, and people are finally abandoning Milton Friedman. He's mentioned these days mostly as a foil for other arguments. And what is coming out of that, it varies depending upon country, but in a paper that is forthcoming in Surya's journal, the Business and Human Rights Journal, I and 2 co-authors argue that what we see emerging is something that we call multi-fiduciary obligations. That it isn't a fully fledged stakeholder capitalism, but the firm is becoming more of a social institution and recognizes that it has fiduciary obligations with regard to stakeholders beyond shareholders. And the second point is that if the mandatory human rights due diligence provisions that are being discussed in the European Commission end up as they are promised, they will end up. Companies will be essentially forced to look forward, to look out at what the risks are that they pose to environment and to people, and to take those actions into account. And insofar as the EU provisions include liability, this suggests almost a revolution in the way in which companies behave. The due diligence that companies have been practicing essentially are what is material, and what is material we'll deal with, and we're required to deal with. Now, if these processes are institutionalized, companies will have to go beyond materiality considerations and examine their impact on people and planet. And those become part of the obligations of companies to manage and to avoid harm.
Thank you very much. Barnali?
Thanks very much. I'll be brief. So I don't know if I want to be pessimistic or optimistic here. Let's go with optimism, okay? So let's say that in 10 years, when we get together for the next edition of Peter's book, we will talk about the fact that there has been a duty of care that's been introduced, that is imposed on all corporations. All corporations will have board oversight over these duties. ESG will not just be, which is what it is right now, really a focus on environmental issues, but the S in ESG will actually become part of the norm in investing. The Rio Tinto example will not be an anomaly. It will be standard practice for all of us today. So, and I think like going forward, what we really need to have is a fundamental rethink about what is the purpose of the corporation, how they operate in society, and what their relationship should be to others besides just shareholders. Thanks.
Thank you very much, Barnali. Surya?
Thank you. I think I will endorse everything what has been said by Peter, John, and Barnali and all that, but I will just add a couple of more points. I think we need perhaps more ambitious norms to dismantle the structures of irresponsibility. For instance, whether the whole idea of gig economy workers, can it be sustainable? Can it be compatible at all, right? So I think I'm talking about more fundamental changes, which companies can perhaps do due diligence all the time, and they can still continue with those models of irresponsibility. So I would like more ambitious norms to change at the roots of those structures of inequality as well. Like, so how many 100 times the chief executive officer of a company should be earning rather than the average worker in the company? So I think we need to look at those norms. And I think we should not get lost into this binding versus voluntary. We need more ambitious norms. Voluntary, binding, semi-binding, that is a separate question. We need a combination of all this. Secondly, what I would like to see is BHR becoming part of the political process. So the elections at all levels must be contested on the BHR issues, whether these are about the living wage, climate change, gender equality. And I think why I'm saying it, because for me, recovering the state is a critical component. Unless we recover the state, which has been totally lost, to some extent from the market force. So we cannot completely recover it perhaps, but at least to some extent, we need to recover it. Otherwise, I'm not going to I'm not going to be very optimistic, but let us try all our best. Thank you.
Thank you very much, Surya. Rae? I'm not sure if Rae is still here, but okay, John Morrison, please then.
Hi, yeah. So Peter, next time a chapter on sport with a picture of the Super League at the top of the page. I mean, actually, more seriously, I think a revelation actually how fans and other interests can, stand up against, six or more billionaires. But more seriously, if we're all agreeing that the S and ESG is a big opportunity over the next 10 years, there is a big impediment within that, is that virtually all financial institutions still align to the Bretton Woods in terms of the IFC performance standards that haven't been renewed since 2011. And there was a big effort to align them with the UNGPs, but there are significant gaps between where the performance standards were and are, and where the world has moved on climate and business and human rights. The OECD tries to align the equator principle. There are, you know, other initiatives which try to plug the gap, but I think getting something better than the 2011 edition of the IFC performance standards and getting export credit agencies and multilaterals and private banks to benchmark against something better would really help. I think we need that if we're going to move forward on ESG with human rights in. Thanks.
Thank you very much, John. James, please.
Thank you. I think there are 5 driving forces I see that will shape the future trade investment landscape and the transformation of global value chains. And this has serious implications for investment policies, investment laws and regulations. The first is the economic governance realignment. And that includes many things in it. And the second is the technology and the new industrial revolution. The third is the sustainability imperative, the global drive for SDGs. And the fourth is corporate accountability, which is mounting, the pressure is mounting further. And the fifth is the resilience-oriented restructuring of the global value chain and investment landscape. So all these will have implications for laws, investment laws and regulations. With regard to ESG standards, I see that kind of a transformation of in 3 dimensions. A shift from kind of icing on the cake to a kind of integration into business model approach, from proliferation to harmonization of standards, and from voluntary to mandatory compliance. And this will be in place fairly soon. So harmonization and the mandatory will be the key. And I think it is happening. And in a few years' time, this will become the kind of standard package for multinationals to operate. Thanks.
Thank you very much, James. And thank you everyone for this very insightful and knowledgeable panel discussion. I'm sure that many debates will move forward beyond this event and will continue at different forums. Peter, you have mentioned in your preface that academics these days are rewarded and encouraged more to publish new work rather than update their own. So we are very grateful to you for taking this trouble and updating this work. And we're looking forward to seeing the new edition in a few years. So congratulations again. Congratulations, Ebbe, on this new edition as well. And thank you very much, everyone, for joining us today. And I hope to see you soon in person. Thank you.
Could I just say a final word of thanks to everybody? I'm really honoured and quite humbled by the panel that's been assembled today, and you all represent different aspects of my life's work. I hope this isn't like an edition of This Is Your Life or something like that, because I aim to stick around and carry on, you know, now that I'm well enough to do research again. But once again, thanks very much. Thank you to everybody who's come to attend. And also I'd like to pay a final tribute to the SOAS Law School, which has given me a fantastic home for developing this work, and where I really, for the first time in my life, learned what comparative law is all about. And I think that's positively reflected in the quality of the comparative analysis in the 3rd edition. And so I look forward to collaborating with everyone on the 4th edition. As I say, the 4th edition starts today.
Thank you, Peter, and goodbye, everyone. Thank you.
Thank you.
Thank you. Thanks.